On May 18, 2026, a three-week trial over the corporate structure of OpenAI ended abruptly inside the United States courthouse in Oakland. Elon Musk had brought a $135 billion lawsuit against Sam Altman, Greg Brockman, and OpenAI, seeking to dismantle the company's for-profit entity and remove its leadership. But after 20 days of testimony, the federal jury deliberated for less than 2 hours. They returned a unanimous verdict dismissing every single claim. Judge Yvonne Gonzalez-Rogers immediately adopted the finding, tossing the case before the damages hearing could even finish. The capital markets reacted instantly. With this litigation overhang removed, OpenAI's path to a Q4 2026 initial public offering, targeting a valuation near $1 trillion, was suddenly clear. Investors treated the dismissal as a resolution of OpenAI's structural questions, but reading the verdict as a validation of the company's underlying conduct ignores the actual ruling. A massive legal question remains completely unresolved. The defense won this case entirely on the statute of limitations. The jury found that Musk waited too long to file his lawsuit. This is a procedural dismissal based on calendar discipline. It is not a substantive ruling on California Corporations Code Section 5250, the law governing whether assets held by a charitable corporation can be transferred for commercial gain. The jury did not address whether Altman and Brockman violated a charitable trust. They did not decide if transferring up to $300 billion in nonprofit assets into a for-profit entity is legally permissible. The verdict successfully neutralized one specific plaintiff's ability to sue. It did not validate the underlying corporate architecture of the AI industry's largest player. OpenAI's lawyers recognized the structural difficulty of defending the conversion on its merits. Instead, they built their defense around a strict mathematical calculation. They invoked California Code of Civil Procedure Sections 343 and 338. These statutes establish a strict 3-year window for charitable trust claims. The defense proved OpenAI's for-profit subsidiary was public knowledge by 2019, well before 2021. Musk's 2024 filing falls mathematically outside this statutory limit. Pursuing a timing dismissal requires significantly less factual development and produces a much faster verdict than litigating the actual conduct. A full trial on the merits would have forced the court to apply Section 5250 to a billion-dollar tech labs transition, a scenario with zero legal precedent at this scale. The judge's pretrial ruling explicitly excluded testimony on AI existential risk. That successfully constrained the entire trial strictly to corporate governance and calendar math. Securing a win on timing also restricts future appellate review. The appeals court will only review whether the procedural math was correct, shielding the actual mechanics of the restructure from higher court scrutiny. By building a wall around the calendar, the defense starved the plaintiff of a trial. The substantive legality of the AI asset conversion remains completely untested. When the jury delivered its verdict at 10:23 a.m., the judge was actively mid-hearing on the damages framework that would have applied if Musk had won. That hearing was instantly rendered moot. This ledger maps Wazon's wrongful gains model, demanding $135 billion in disgorgement, dismantling the PBC, and removing Altman and Brockman. But the judge identified a flaw, legally conflating an early-stage charitable gift with a startup equity stake. The judge noted the analysis seemed devoid of connection to the underlying facts. But because the trial ended on procedural grounds, the court never officially ruled the damages framework invalid. This $150 billion aggregate exposure model is now permanently on the public record. It exists as an active template for any future plaintiff who can prove valid standing within the statute of limitations. Musk's specific federal lawsuit is closed, but parallel channels of state and federal regulatory oversight are wide open. In December 2024, California Attorney General Rob Bonta opened a parallel investigation into the restructure under his supervisory authority over charitable trusts. That track reached a resolution in October 2025. Bonta permitted OpenAI's conversion to a public benefit corporation to proceed, but only subject to a negotiated settlement. This matrix maps state concessions. OpenAI agreed to safety commitments, and the foundation retained $130 billion in equity. Crucially, Bonta didn't mandate full disgorgement. Now, the SEC will review S-1 disclosures, while the IRS retains authority to examine the asset transfer's fair market value. Corporate oversight in the artificial intelligence industry is moving away from individual founders litigating personal grievances. These new regulatory actors hold a structural advantage over private plaintiffs. They possess automatic standing and continuous ongoing jurisdiction. OpenAI traded a discrete bounded private lawsuit for a permanent state of multi-agency institutional oversight. The immediate objective for OpenAI and its bankers is executing the Q4 2026 mega IPO. The financial stakes are massive. The company is targeting a capital raise of at least $60 billion, aiming for a valuation between $852 billion and $1 trillion. To underwrite that offering, investment banks must calculate the S-1 risk spread, quantifying the burden of OpenAI's disclosures to present to institutional investors. We can see the weight of that burden by looking at Anthropic as a comparative mirror. Anthropic was structured as a public benefit corporation from its inception. OpenAI carries the complex baggage of a contested legacy nonprofit conversion. Their S-1 will be heavily burdened by mandatory disclosures detailing the Attorney General settlement, the Lessig amicus brief, and unresolved charitable trust questions. Underwriters must now price the spread between a structurally clean competitor and one carrying unquantifiable legacy regulatory exposure. The verdict delivered a tactical calendar win. It did not deliver a strategic legal precedent. The commercial conversion of a $300 billion charitable asset remains completely unvalidated by any Article III court on its merits. As AI governance enters the public company era, that specific corporate history will face rigorous, sustained market scrutiny during the S-1 review. While a procedural technicality cleared the path for the largest tech IPO, it leaves the underlying corporate foundation highly vulnerable to a shifting regulatory landscape.